Did you personally serve defendant?
I believe that I did.
You don't believe. Take your beliefs to church, got evidence. I want what specifically happened. Did you put it in her hand or not? You know, as an attorney,
No,
what
I did
person.
not put it in her.
Then why did you sign the affidavit? That is a breach of your ethics.
This is a motions hearing for a civil lawsuit. It seems one of the litigants is using her social media to disparage the opposing side, and the judge has to issue a gag order. That's not the real story, but it sets up the attitude Judge Aquilina has going into the bigger problem they have. It seems the lawyer who personally served the defendant actually served the defendant's front yard, and then she lied to the court about it. Let's roll, nerds.
Defendant Miller stated in point 8 of her response, plaintiff's request is unnecessary because defendant has not made a public post about this matter in months and does not plan to post about it. The plaintiffs just became aware this morning of some additional posts on Reddit from the screen name PWL Julia from 9 and 8 days ago posting about this matter.
Please raise your right hand. Do you swear? It references a PWL Julia. Is that you, ma'am?
I did. My account I used.
She said that is my account that I use. Did you write those?
Yes.
Okay, so despite receiving a cease and desist letter and being advised not to talk about this, you've continued to do it, but just on a different platform. Is that correct? Yes or no?
Yes, I was responding to a screenshot somebody had posted.
Okay, I mean, this is ridiculous. This is a very good organization. I don't know what's gone on. We have a court of law to have a jury trial or a bench trial to figure out damages or whatever it is you all have complained about. But this doesn't help anybody's case. So it's stirring the pot for no reason and could hurt either side. So the stipulation that I would like to see, and you all can draft it and argue with me here, is that all this crap gets taken down and there is no more. And we fight about this in a court of law with evidence, not speculation, supposition, and tainting of a jury pool that doesn't necessarily need to be tainted. Can we do that?
Yes, Your Honor. I'll direct my client to stipulate to that, and we will stipulate to that, Your Honor.
Is there freedom of speech? Yes. And I know that's been asserted here too. And that's part of the Constitution. The problem is that you are ruining your case. All of this is going to be found out one way or another. It will be used to impeach you, discredit you, and it's harmful to the case. So I would ask you to refrain from using your personal account, Reddit, Instagram, Facebook, TikTok, any of the platforms out there from discussing this. So maybe we could craft an order saying that during the pendency of this, there is no discussion publicly on either side. It should be mutual. That's essentially a gag order. And if you've got some allegations, it takes evidence. You have a very competent attorney, so does the plaintiff, and they'll present it to me and I will make a decision. Does that make sense to you?
Yes.
Great. Any other questions at this point?
I have no questions, Your Honor.
Thank you.
Yeah, thank you.
Now, what are the other issues here?
This is a motion to strike and request for evidentiary hearing on this matter relating to the proof of service. What I want to point out first is that I'm not raising a jurisdictional issue. We're in this court. We've filed an answer. We understand that. We're here. That's not my purpose in bringing this to the court's attention. But I thought it was important to bring this to the court's attention based on what this underlying complaint is all about, which is plaintiffs asserting that my clients breached fiduciary obligations and broke a bunch of rules in relation to this company. Meanwhile, you can see my client's affidavit attached as one of the exhibits. They did not personally serve my client. They did not hand the documents to my client. They left it on her porch and she found it a few days later.
Was there an alternative service signed by the court?
I do have Ms. Stoner here. She was the attorney handling the matter at the time. I only know what is in the court's record, which is the proof of service that was filed by Ms. Stoner.
Okay, but it has to be personal or through the mail unless the court allows attacking or otherwise. So, but counsel, I understand you're asking them to abide by the rules, but you've appeared before the court. You're not denying the jurisdiction of this court or that there's a case. What would you like me to do on this?
Well, it's a clear violation of the signature rule
Okay.
and sanctions to some extent. I mean, this is an attorney. This isn't just some random processor. This was the company's attorney. And they're alleging that during the course of all of their time at this company, my client did all these bad acts. Meanwhile, they're presenting a document to the court. And I came in here understanding the court may not, want to dig into this. I understand that, Your Honor. But when I'm dealing with, my client had these documents from June or July, and they just sat on it right until the moment that the summons was going to expire. And then they filed this, I think probably knowing that it was dubious, and it's signed saying, I personally served Juliet. That didn't happen.
All right. Let's call the witness. We have one. I've got time this morning. I had another issue canceled. So, ma'am. Please raise your right hand. Do you swear or affirm the testimony you're about to provide be the truth, whole truth, and nothing but the truth and the penalty of perjury?
I do.
You may have a seat. Of the chair writers of the microphone and spell your name for the record.
Rebecca Stoner, RMECCA, STO.
And ma'am, you are an attorney.
I am.
Did you personally serve defendant?
I believe that I did.
You don't believe. What I always say to people is take your beliefs to church, got evidence. I want what specifically happened. Did you put it in her hand or not? As an attorney, what person
put it in her.
Then why did you sign the affidavit? That is a breach of your ethics.
At the time, I believed that I had personally served her.
What is your understanding of personal service?
Well, she had been an unwilling recipient. I had sent her a certified mail to her address and she had flat rejected it. And so I thought that if I brought it to her household and saw her take it off her porch, that would be adequate. And I was wrong. Liz corrected me on that.
That is wrong. What you do, and I sign these pretty regularly every week. I have a stack of people who do the same thing. No one wants to accept paperwork from a lawyer. So there is a motion that you file that they've been uncooperative. So you use personal service with a process server. You use attacking, publication, and there's a very specific court rule. And as counsel, that's a very basic rule that you should know. I am unclear how you thought what you did was acceptable, ma'am.
I don't generally practice law. I am a bar attorney, but I work in contracts and have for the past 15 years. The only reason I got put in on this matter was I'm a volunteer with Punks, and I got a very tearful series of phone calls from the board when this matter came to the court. So I volunteered to assist.
Your Honor, empathy does not negate your responsibilities to abide by the law, the statutes, the court rules that we all operate under. And the answer is no. If you don't feel you're able to handle a case, you say no and you refer it on if you can. Were you going to file an objection?
Judge, what I was going to object to was Ms. Stoner testifying about anything that she discussed with her clients, as that is attorney-client privilege.
Okay. Well, I'm only interested in this, but you should not, again, reveal anything you've discussed with your client. Did you have any questions?
I have no further questions. We've established.
Additional questions?
No, Judge, thank you.
Let me sit down, ma'am.
Yeah, I appreciate Ms. Stoner's honesty at that moment. I mean, that's nice that she was honest about that. I mean, obviously, it's a significant issue, frankly. I mean, we're here in court. It's not a jurisdictional issue. I'm not worried
Okay,
about it.
so are you waiving the defect in service so we can proceed, or do you want this case do you want them to personally serve you, or we can get you served in court, or what would you like?
No, that issue is waived, Your Honor. We're here. We filed in the appearance. That's not my purpose with this. Your Honor.
Okay.
My purpose was potentially getting it stricken and potentially sanctions. Whatever the court's inclined to do, that's fine. I think that it is a sanctionable issue. It's a violation of signature rules. She filed a proof of service saying she served something that she didn't. And I appreciate her honesty, but that's a significant issue. I deal with these service issues constantly, all day, with different cases I have. And this is a very sensitive topic. You can't just file fraudulent documents with the court. That's what it was.
So, sir, as to this particular motion, how long did it take you to draft?
Drafting and filing about maybe an hour to 2 hours.
And so how much do you charge an hour for this? How much did you charge your client?
$325 an hour.
Great. Ma'am, you are sanctioned $325. I'm just going to leave it at that because the rest the state bar is going to have to take care of. Once I hear a violation, it has to go to the state bar. There is, and they'll take care of the rest. And you're going to have 30 days to pay that to counsel.
Thank you, Your Honor. I'll move to the next motion. I appreciate it.